Hey Jimmy, it's great to see my favorite client. Thanks for meeting with me today. What's that? It's my new invention. Takes the rainwater that falls on your umbrella, filters it, and then collects it in this water bottle. Want a drink? Wow, if this is as great as your past ideas, I can't wait to see it on the market. I know, no waste. Think you can patent it? Well, is it novel? Have you ever seen anyone selling something like this before, or a picture of it anywhere? Well, I've certainly never seen anything quite like this before. I've seen upside down umbrellas that collect rainwater, but never anything that works right side up. Great. We should do a prior art search before we file just to make sure, but it sounds pretty novel and non-obvious to me. And I can totally see the utility from the fact that you've gotten it to work without having to turn it inside out. So, you know what that means. It's patent time! Welcome back to Introduction to Intellectual Property, Patent Law Edition. In the last video, I talked about the history of patent law, beginning with 15th century Italy. Now we'll step back into our time machine and fast forward to the modern day. Today, I'm going to describe the institutions of the patent system. In other words, the elements that it consists of. The first and most foundational law governing the patent system is the Constitution. Article 1, Section 8, Clause 8, the IP clause. Because of this provision in the Constitution, patent law is federal law. That means we're going to be looking at federal statutes, laws that were enacted by Congress. Our current patent law is codified in Title 35 of the U.S. Code. Section 101 sets out the basic idea. It states that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent. Additional parts of Title 35 provide more details. Section 154 states that every patent shall contain a short title of the invention and a grant of the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or of importing the invention into the United States. It also states that the length of the grant ends 20 years from the date on which the application for patent was filed. In addition, there are some basic requirements for an invention to be patentable. Section 102 requires that the invention be novel, in other words, something new, and explains how that's determined. Section 103 extends that newness requirement to preclude obvious variants of existing things, such as making a doorknob out of ceramic instead of metal. Finally, Section 112 requires that a patent application explain how to make and use the invention, and also that the application must clearly claim what the invention is. I'll talk more about these last two requirements in a moment when I walk through the patent document. Understanding these requirements will make up the first half of our unit on patents. For over 200 years, the responsibility of determining whether to issue a patent has rested principally with the United States Patent Office, an administrative agency of the federal government. Today, that agency, which resides within the Department of Commerce, is responsible for examining both patent and trademark applications. We'll talk about trademark applications much later on in the course. The process of obtaining a patent begins when an inventor files an application with the Patent Office. That application, which contains both a description of the invention and what the inventor wants to claim, is then reviewed by a government employee called an examiner. The examiner makes an initial assessment of whether to allow the patent claims sought by the applicant. If he or she refuses to allow the claims, the applicant can respond. If the examiner still refuses to allow the claims, the applicant can appeal, ultimately to the federal court system. Although with multiple rounds of review already taking place at the Patent Office, appeals to the federal court system are relatively rare. This brings us to the patent document itself. Did you know that there are actually 3 types of patents? When most people think of patents, they think of utility patents, which grant rights over useful inventions. But there are 2 other types of patents, design patents, which cover the appearance of an article of manufacture, and plant patents, which cover asexually propagated varieties of plants. We'll focus on utility patents and won't cover design or plant patents in depth. To walk you through a patent, I'll use this utility patent for an insulated beverage holder. You can access a copy of this patent on the course Pressbooks site, linked in the description. Keep in mind that I'm showing you this patent just to give you a sense of what a patent looks like, so that you'll have some real-world context when we start talking about the law of patents. I'm not expecting you to know small details about the patent. Instead, focus on general structural characteristics. The first thing you might notice about the patent is the title. Although it's a frequent subject of sensationalistic headlines, the title of the patent isn't actually all that important. It's basically a quick way to reference a patent, although even then it's of limited use because patent titles can be very similar. Instead, we use the unique patent number to refer to a specific patent. Often we'll also use a shorthand of the patent number consisting of just the last 3 numbers preceded by an apostrophe. For example, I call this the 497 patent. The patent also lists the inventors and identifies whether the patent issued to an assignee. In this case, the inventor was J. Sorensen. Another thing to look at on the face of the patent is the date. The most important date isn't the date the patent issued. It's the filing date, because that's what's used for determining whether the invention is new, and because the patent term for most patents filed after 1995 is 20 years from the effective filing date. There are 2 places to look for the filing date: the date the application was filed, here, and the dates of any earlier applications that a patent claims priority to. Together, these pieces of information will tell us the effective filing date, which is the earliest date to which the patent claims priority. In this case, the application date is the only filing date on the patent. There aren't any earlier filing dates that the patent claims priority to. You'll also notice that the patent contains an abstract of the invention. This is a short summary of what the invention is. The real contents of the patent start after the abstract, with drawings. Nearly all patents must include drawings of the invention. After the drawings, there's a long body of text in 2 columns. This is typically called the specification, or the written description of the invention, and is required by Section 112. This part of the patent typically describes the technological field, provides a summary of the invention and a description of the drawings, and then launches into a more detailed description of the particular example of the invention that the inventor has created. Patent attorneys call this the preferred embodiment. Finally, at the end of the patent are the claims. The claims set out the legal boundaries that the patent grant encompasses. In other words, the claims define what the patent owner has the legal right to stop other people from making, using, selling, or importing. So how did Sorensen's attorneys claim the invention here? Here's one of the claims. Notice how formulaic the language of these claims is. That's because there is a formula for writing patent claims. They take the form of a single sentence that begins with a preamble, followed by a transition, and then concludes with a set of claim elements or limitations. Basically, what the claims do is provide a set of elements that must be met when analyzing whether the invention is patentable, or when the patent owner is enforcing its rights against someone else. This is just like you might think of elements in other areas of the law, like the elements of a tort claim. The patent system relies on private enforcement. If someone's infringing your patent and won't stop, you don't call the police, you find a lawyer and sue them. Patent infringement suits must be filed in federal district court, or in some cases in the International Trade Commission, or ITC, a quasi-judicial agency. Decisions of the district courts and ITC are appealed to the United States Court of Appeals for the Federal Circuit, a federal appellate court with subject matter jurisdiction rather than geographic jurisdiction. This means that the Federal Circuit hears appeals from patent suits from any district court in the country. The Federal Circuit also hears appeals from the Patent and Trademark Office. The result is that almost all patent cases end up being reviewed by the Federal Circuit. Occasionally, the Supreme Court may review a Federal Circuit decision, but that's relatively rare. Next, let's talk about patent infringement. Patent infringement occurs when someone makes, uses, sells, or imports the claimed invention. What's the claimed invention? Well, it's something that meets all the limitations of at least one claim in the patent. It's not necessary that the person doing this act, who we'll call the accused infringer, knows or should have known that they're infringing the patent. Patent infringement has a strict liability standard. Usually, the main question in a patent infringement lawsuit involves comparing the accused product or process to the patent claims and determining whether all the claim limitations are present in the accused product. However, asserting a patent in court is not without risks to the patent holder. Although the Patent Office's decision to grant a patent is given deference, courts still review whether the patent complies with the substantive requirements of patentability. While the court may conclude that the patent is valid and infringed, another possible result is that the court concludes that the patent is invalid because it fails to meet the requirements of patent law, a risk to the patent owner. With this background, you should be in a good position to read our next judicial opinion, Bowman versus Monsanto. The facts in the Supreme Court's decision are fairly simple. Bowman took soybeans from Roundup-ready crops, planted them, harvested the soybeans, and then replanted the soybeans he'd harvested. Monsanto said that this constituted infringement of its patent on glyphosate-resistant soybeans, because Bowman was making the patented invention. Unlike many patent cases, there was no dispute that Bowman's actions involved the claimed invention. Rather, as you'll see, the nuance in this case is whether a doctrine called the first sale doctrine, or exhaustion, applied. The basic idea of exhaustion is that once a patent owner sells a patented product, its rights in that item are exhausted. The buyer can use or resell it without infringing. But exhaustion doesn't apply if the purchaser then goes and makes an unauthorized copy of the product. The twist in this otherwise straightforward case was that the product in question was a seed. As you read this case, think about the court's reasoning and the sources of legal evidence that it draws upon in reaching its conclusion. A water collecting umbrella? Whoa, these inventors! What'll they think of next?